Therefore, my Lord, allow me to provide a brief history to the current bill that is before these courts for adjudication. Specifically, my Lord, that this bill is but a culmination of an attempt by the National Assembly to insist on having the National Government Constituency Development Fund as a fund run by members of Parliament. It's on record before the superior courts of this country that the NGCDF question has been a question for determination in at least 5 different cases. 2 High Court decisions, 2 Court of Appeal decisions, and a Supreme Court decision. And between 2013 and 2025, when this bill was submitted to Parliament, the National Assembly is on record having amended that CDF Act of 2013 a record 5 times. And the reason why the amendment was undertaken was purely, my Lord, to undermine the court processes or to respond to the findings of the court with respect to the unconstitutionality of the NGCDF. Therefore, my Lord, the current attempt to have the National Government Constituencies Fund inculcated or be provided for under the Constitution is but a continued effort to ensure that by nook and crook, the NGCF continues to be implemented, regardless of whether the constitutional question still abounds. My Lord, what the National Assembly seeks to do is, after all these court processes, after realizing that the general underlying position by the courts is that the NGCDF as envisioned is unconstitutional, what the National Assembly has sought to do is to do away with that Article 2.4 limit on their ability to continue implementing NGCF by including that NGCF in the Constitution. Doing that will eliminate any constitutional challenge or judicial scrutiny on the basis of constitutionality. My Lord, what is contained in this bill is, one, the National Assembly understands that NGCF is implemented at the constituency level, but to be able to succeed in amending the Constitution, there are 2 routes. One is the popular route and 2 is the parliamentary route. The parliamentary route will require the support of all members of Parliament in the National Assembly and in the Senate. So what members of the National Assembly did is, instead of only coming with the NGCDF to be included in the Constitution, they came up, they added the National Government Affirmative Action Fund to be able to bring on board or to throw a bone to the members of Parliament that are elected at the counties level, otherwise referred to as the women representatives. Therefore, the National Assembly is already interested. Members of the representatives of the county assembly, as well as the representatives of the counties, already have an interest in seeing this bill through. And now they realize that also the Senate, they have to go through the Senate. And what they did, they came up with the Senate Oversight Fund to be able to interest the members of the Senate also to have a bone insofar as ensuring that this bill passes. Hence, what has been brought together here, my Lord and my Lady, is a conglomeration of funds that otherwise ought not to exist, but funds that the National Assembly wants approved and included in the Constitution purely through a parliamentary process where each of the actors for the parliamentary route has an interest.
Where did they leave the World Fund?
The World Fund, my Lord, is at the county level.
Yes. Why would they also entice them?
Because, my Lord, the parliamentary route does not require them to necessarily pass the amendment through counties. It's only when a decision has been made under Article 256, that the bill needs to go through a referendum, that then the bill is taken to counties.
So there's also another constitutional petition where the word people also want their own fund. Are you aware of that?
My Lord, that is the consequence of allowing this amendment to go through. That the county assemblies will as well want a fund that they will run as members of the county assembly. And my Lord, as much as the question of the constitutionality of that position is not in contention in this case, my Lord, that is the mischief that then is going to be created. That if members of the National Assembly are allowed to have funds that they individually run, then it cascades across the legislatures at the county level. My Lord, again, is that background. I then move on to be able to respond, to address the court on the 3 issues that are before this court. And largely, my Lord, is just a number of questions, because when the superior courts of this country set out canons of constitutional interpretation, importantly, the principle of harmonization